Michigan, and Professor of Human Rights and Equality Law at Queen's University, Belfast, having previously been the Professor of Human Rights Law at the University of Oxford. He's a distinguished graduate of Queen's Belfast, Yale, and Oxford. Christopher is also a practicing barrister entitled to practice both in England and Northern Ireland. He's also one of the very few academics who's had a major impact on social life in numerous places for the better. I've known him since I was 11 years old. When he was 17, I had to emphasize your maturity, Chris. We attended the same grammar school in Northern Ireland, St McNissie's College, Tower, set in the Glens of Antrim. So you'll forgive me if I emphasize two transformations of our home island, for which Chris deserves the lion's share of the credit. First, through advising the opposition Labour Party in the Westminster Parliament, Professor McCrudden became the de facto prime draftsman of the Northern Ireland Fair Employment Act of 1989, the most effective and targeted affirmative action programme ever implemented within the United Kingdom. His knowledge of US programmes and his comparative scholarship, combined with his assiduous attention to drafting detail, led to a genuinely transformative reform. He showed that Northern Ireland could be reformed, and he did so as an astute public lawyer who was able to use Irish-American pressure on inward investment to oblige a very right-wing UK government to pass legislation utterly at odds with its official ideology. His second major achievement, in my view, is the new Section 75 of the Northern Ireland Act of 1998, which in effect is now the region's new constitutional text. Under its provisions, any public authority in carrying out its functions relating to Northern Ireland is obliged to have due regard to the need to promote equality of opportunity, and I quote, between 1, persons of different religious belief, political opinion, racial group, age, marital status, or sexual orientation. 2, between men and women generally. 3, between persons with a disability and persons without. And 4, between persons with dependents and persons without. Pretty comprehensive. Without prejudice to these obligations, a public authority is also required in carrying out its functions to have regard to the desirability of promoting good relations between persons of different religious belief, political opinion, or racial group. This too is a remarkable piece of legislative drafting, remarkable for its wide-ranging impact in mainstreaming equality in public policy. It has certainly had a far greater impact on public life in Northern Ireland than the project to establish a distinct Bill of Rights for the region. Chris's intellectual distinction has been appropriately recognised in his election to the British Academy in 2008 and his current hold on a 3-year Leverhulme Major Research Fellowship. Of his many publications, I would strongly recommend Buying Social Justice, published in 2007. That's not a mafia treatise. It's a story of how government procurement policy can be successfully used to pursue social justice. This spring, he will publish Courts and Consociations, Human Rights versus Power Sharing, co-authored with an obscure professor from the University of Pennsylvania. Bill Burke-White, who will act as Professor McCrudden's discussant, is certainly not an obscure professor from UPenn. He's Deputy Dean and Professor of Law at our law school. He holds 4 degrees from Harvard and Cambridge. He's an expert on international law and global governance and served in the Obama administration's first term on Secretary Clinton's policy planning staff. Among his many areas of expertise, he's written on international human rights and the challenges of international legal regulation. So he's an entirely appropriate discussant for Professor McCrudden. The draft paper has been circulated in advance, so its full content will not be delivered. It fits elegantly into our programme on democracy, citizenship and constitutionalism, directed by Professor Roger Smith, and this year's programme, Making Constitutions, chaired by Rick Beeman. In our opening session, we heard extensive and eloquent reflections on the generally diminished role of American constitutionalism in the world beyond the United States. Today, we're going to hear about the philosophical importance of comparative borrowings in legal and political argument and deliberation over rights. Chris will present his paper for 20 minutes, and then we'll hear Bill's response. I will allow Professor McCrudden a brief rejoinder and then open up questions to the floor. Thank you very much. Put this on.
Well, thank you, Brendan, for that extremely generous, if over the top, introduction. I'm delighted to be here. The last time I was in Penn, I was telling Brendan before we started, was many years ago. I was invited to the law school by a professor called Clyde Summers, that some of you will know, very, very prominent labour law professor. Unfortunately, nobody told me before I started that Clyde also suffered from narcolepsy. So within about 3 minutes after I started, he went absolutely sound asleep, which everyone else in the room regarded as entirely normal. And I was taken aback, you might say. So the other unfortunate thing was that 3 minutes before I ended, he woke up and then proceeded, not having heard anything that I said, to ask the most penetrating question of any in the audience. So I'll understand if people go to sleep, thinking of this as being a characteristic of University of Pennsylvania. So as Brandon said, I'm going to talk about the use of comparisons in the human and constitutional rights context. But I don't want to use that as a way into a discussion about academic use of comparisons. I want to think about it in the context of how comparisons are used in human rights discourse by actors in the human rights system. And quite a lot of the discussion most recently in the US has been about judicial borrowings. I'll use the term human rights comparativism or comparisons to indicate this notion of a kind of borrowing from one jurisdiction to the other. And quite a lot of the discussion has been about judicial borrowings, and I want to expand that discussion, taking it into account, but also considering and bringing into account the much more recent historical and political science research that's been done on the use of borrowing in non-judicial contexts and in constitutional rights contexts, both historically and currently. What I'm particularly concerned to think about and help you think about, and you in turn help me think about, is what the popularity, as I'll argue, this comparative method in the drafting and interpretation of constitutional rights and human rights says about the nature of human rights. So what I'm particularly interested in then is exploring what, if anything, these phenomena of constitutional and human rights taken together and use of borrowings or comparisons says about the nature of human rights viewed philosophically, not viewed legally. Now you'll understand immediately I'm now immediately going outside my comfort zone. I'm a lawyer, and therefore speaking to a group of political scientists about political theory is a risk, to put it no higher. Now I'm emphasizing that because I need to distinguish my project today from Jeremy Waldron's recent book that some of you will have seen based on the Storrs lectures. Jeremy's book is effectively the first full-length monographic treatment of American judicial borrowing from a jurisprudential perspective. And his concern is to develop essentially an appropriate legal theory or jurisprudential response to and justification of the phenomenon of the judicial use of this kind of comparison. And his argument briefly is that the foreign law used in the judicial setting constitutes what he calls jus gentium, positive law grounded in an emerging global consensus. When courts apply this jus gentium, they're applying legal principles, he says, that supplement their national legal rules. That's his essential argument, as I understand it. There are several elements of that book that are distinguishable from what I'm trying to do. He mentions, first of all, though he doesn't really address, the role of foreign experience in the legislative and broader political contexts. And you'll remember that it's in the legislative drafting, constitutional development, and non-judicial context that I'm as interested. He also doesn't primarily concern himself with the phenomenon of judicial borrowing outside the United States, and I'm more concerned with external than I am with internal use of borrowings. Jeremy's also concerned with developing a general theory that applies to the use of foreign law generally in the judicial context, and I'm focusing specifically and only on the use of it in the constitutional and human rights context. And his concern is to develop a theory of law. Mine is to develop a theory of human rights. I hope I've said enough to distinguish my project from Jeremy's, though I'll occasionally refer to elements of his argument as we go on. So the crux of my argument, which engages with a different set of literature than Jeremy does, I'm primarily concerned to engage in a discourse with a set of philosophical writers whom I'll identify in a moment. The crux of my argument is that these recent political philosophers have not attempted systematically to incorporate into their explanations two features of human rights discourse that I'm particularly concerned with. The first is the interrelationship between constitutional and human rights. And the second is this use of experience from other jurisdictions in the development and interpretation of constitutional and human rights norms. So my broader question is whether there's something about these phenomena, these two phenomena, that tells us something fundamental about the different ways in which we view the nature of human rights, about where they've come from and possibly what their trajectory is. So the starting point then is that I'm interested in seeing to what extent these two phenomena, the relationship between constitutional and human rights and borrowing generally, what implications they have for attempts to develop a normative theory of human rights. The first question, I suppose, is what do we mean by a normative theory? And in this, Joseph Raz, I think, whom I'm viewing for the present purposes as a philosopher rather than as a lawyer, which is what he is, Raz has identified essentially the task of a theory of human rights as comprising two main elements. The first, he says, is to establish the essential features which contemporary human rights practice attributes to the rights it acknowledges to be human rights. So in other words, to map contemporary human rights practice in terms of its attribution of the idea of human rights to a particular set of claims. And secondly, to identify the moral standards which qualify anything to be so acknowledged. Now, the philosophers I want to engage with are essentially Rawls, Raz, Ignatieff, Beitz, and to a certain extent, Waldron. And broadly, they follow the approach that has been called in the literature a political theory of human rights, distinguishing it from naturalistic or agreement-based theories. And I'll come on to the implications of that in a moment. So my project is quite a limited project of engaging a particular set of issues that arise in human rights discourse and seeing to what extent these philosophers address those and take them into account in the understanding that they have of developing a normative theory of human rights. So there are two particular problematic aspects, I think, of the development of this political theory of human rights that I try to identify in the paper. The first is the importance that's attached and the understanding that's given to the notion of contemporary human rights practice. So you remember that Raz says that the first task is to establish the essential features which contemporary human rights practice attributes to the rights it acknowledges to be human rights. So a central issue then is, what do we mean by human rights practice? And we shouldn't gloss over the importance of this question for political theories of human rights. Its importance derives from the central place in the structure of determining the foundations of human rights for political theories that the idea of human rights practice holds. Political conceptions of human rights, then, share an attempt to develop a normative theory that's in tune with and builds out of human rights practice, rather than the other way around. And I find that a very attractive project. So the question that arises, therefore, is why such an important emphasis on human rights practice? And Bites, in his recent book, I think puts it quite well. He says that a political conception of human rights, in a political conception of human rights are seen as a political doctrine constructed to play a certain role in political life. So we should frame our understanding, he says, of the idea of human rights by identifying the roles this idea plays within a discursive practice. It's essentially a functional account, as I understand it. Functional, I'm not using functional in a technical sense here. So the question, therefore, justified to prevent action by the state against those on the territory of that state. Thanks so much. So essentially then, human rights are justified insofar as they allow or prevent international intervention into other states. And I think increasingly it's the case that the distinction that Rawls and Raz seeks to emphasize between constitutional rights and human rights has become extremely fuzzy and indistinct, at least in those jurisdictions that enacted their constitutional rights protections after World War II, which is the bulk of states, but even in those states that enacted them before as well. So I suggest, therefore, that we should regard human rights as including aspects of domestic constitutional rights protections. But even then, in terms of what we mean by human rights practice, I think there's a more significant issue about the notion of human rights practice that they're using. And this is, what do we mean by human rights practice? And it's in this context that I want to introduce the question about the use of the comparative method or judicial borrowing. So is that part of human rights practice? It's very unclear what they mean by human rights practice in this context. Jeremy Waldron, in his book that I mentioned, seems to imply that there is such a practice of judicial borrowing. And I'm much less sanguine than Jeremy on this point, mostly because although there is, I think, significant evidence of comparative method being used in human rights discourse, the reasons why human rights discourse involves comparison seem to be varied in the extreme. So in other words, there's lots and lots of different reasons why the practice is used, even though there is a common practice. Whether that constitutes a human rights practice or not, it seems to me to be problematic. So I suggest in the paper that we need a considerably more detailed typology of the uses of the comparative method in human rights or constitutional rights context than Jeremy provides, and a much greater clarification of what human rights practice actually involves than Rawls or Raz provides, before we can say that with any confidence, I think, that the comparative method is a central part of human rights practice. So in other words, if there is a bottom line here to the point I've just made, it's that I think there is a degree of laziness in the philosophers that I've identified in terms of identifying the actual practice that they say they're engaging with. But let's assume that there is a human rights practice that involves the comparative method, the way that I've been identifying. So let's assume, for the sake of argument, that the comparative method is a central part of human rights practice in the sense of constituting part of the system. The rest of my discussion in the paper proceeds on that assumption, and essentially it raises the, I think, more interesting question of if there is such a practice that you can call a practice, then what's the role of the comparative method in the context of Raz's second limb of his role for a human rights theory? So does the comparative method play a role in identifying the moral standards which qualify anything to be acknowledged as a human right? So what then is the normative role of the comparative method, if any? So can we say that the comparative method provides a good moral reason for identifying a particular norm or value as a human right in the political sphere, or in the context of drafting a new Bill of Rights or whatever, for example? And again, I'm identifying, I think, several problematic aspects of Rawls and Raz's account, not least because I think they render almost unarguable as extensive a role for comparative methodology in the development of human rights norms as are assumed to be occurring if you identify them as part of human rights practice. And that's due to the view that human rights are justified, as I said before, essentially only insofar as they justify international intervention. And that would seem to leave only a very narrow role for the comparative method, one that current practice clearly goes well beyond. So James Gryphon, in a more recent book, is surely right. James Gryphon essentially taking a non-political, naturalistic justification for human rights, is surely right when he says that the point of human rights go beyond Rawls's idea of human rights as merely establishing rules of war and conditions for justified intervention. For Gryphon, and I'm sure he's right on this, human rights quite obviously have point intranationally as well. So it's with this, and in the last 2 or 3 minutes that I've got, I want to turn to Charles Beitz's more recent book called The Idea of Human Rights, that some of you will be familiar with, I think, who seems to me to provide a much, much more convincing political account of human rights than either Raz or Rawls. And unlike Raz and Rawls, Beitz sets out in detail the most important features of what he regards as human rights practice. And again, unlike Raz and Rawls, he doesn't seek radically to distinguish the domestic practice of constitutional rights, creation and interpretation, from the global practice of human rights. I think he's right in that. So Raz's justifying international intervention becomes Beitz's object of legitimate international concern, which comes, I think, much closer to the idea. So although Beitz doesn't specifically address the role of comparative method in human rights practice, it's not particularly challenging to see how it would fit within his account. He says essentially what justifies the label of human rights being attached are interests that are of sufficient importance to be suitable objects of international concern. And to be seen as such, he says, the account should not depend exclusively on beliefs and norms that are specific to a single culture or way of life. And therefore the question of how to satisfy the requirement that the interest is not simply a parochial one, I think is likely to bring a comparative method very much to the fore in terms of justifying. So I'm suggesting, therefore, that Beitz's account is much more capable of integrating successfully what seems to me to be occurring in human rights practice than either Raz or Rawls. But it requires, I think, not insignificant variations on Beitz's model for it to be able to be as fully integrated as our earlier description of human rights borrowing indicates that it should. And I've suggested in the paper several ways in which Beitz's approach might best be amended. The first is a rejection of his extremely sharp line that he draws between what he calls a juridical paradigm of implementation of human rights and a political paradigm. And I suggest in the paper that that sharp dichotomy, I think, is problematic. Not least because bodies acting under his juridical paradigm demonstrate many of the same features as those acting under his political paradigm. But my main point in terms of addressing Beitz's argument is rather that he seems to place, from my point of view, insufficient weight on the extent to which global human rights practice draws and is contingent on bottom-up social movements fighting to have their own and others' interests recognized as worthy of inclusion as an object of concern. He says international concern. Such movements, it seems to me, politically use the banner of human rights as a portmanteau moral basis for their specific claims. So they seek to use human rights as a moral umbrella, if you like, to strengthen the normative weight of a specific claimed right. Hence their desire to be seen as part of a human rights movement. So Beitz's description of human rights practice, and I think actually Rawls and Raz's as well, despite their explicit denial that this is so, appear to be too statist, if you like, to fully encompass this dimension of a bottom-up approach. And my concern in that regard is heightened by Beitz's statement that, quotes, human rights do not appear as a fundamental moral category. As such, rather, he suggests, we should seek explanations of the normativity of human rights in each particular human right. So you shouldn't think of normativity attaching to human rights as such, but rather to each individual human right. And that seems to me not to capture adequately the moral connections made in human rights discourse between those norms that we consider human rights. In other words, that there's something more going on. The group of human rights is greater than simply their individual content. Beitz himself appears to accept that what holds human rights practice together is the idea that the interests encompassed by human rights are ones, quotes, intersubjectively recognizable as sufficiently important or urgent. Sufficiently important or urgent to become suitable object of international concern. So what I'm suggesting, therefore, that Beitz touches on but doesn't sufficiently develop this notion of the intersubjectivity aspect of human rights. Now, Gryphon, rejecting a political approach, essentially argues that we need to get beyond a purely functional approach to our understanding of what human rights are. So essentially he's rejecting a political approach. He says we must have a sufficiently rich understanding of the value that rights represent. So for him, for Gryphon, a rich understanding of the dignity or worth of the human person would be required. And he asks rhetorically, do not human rights have their own intrinsically valuable purpose, the protection of human dignity? What more point do human rights need than that, he says. My response to that is, well, human rights needs an awful lot more than simply that, hence the value of the political approach. But on the other hand, my suggestion would be that Beitz's political approach needs to be supplemented by greater attention to the idea of intersubjectivity in our understanding of human rights in order to capture the political dimension of the moral importance of human rights, taken as a whole. I'm conscious of my time, so I won't delay any further. All I suggest is that in terms of the paper, that I'm suggesting that the current notion that human dignity is what provides the glue, as it were, the moral purpose behind human rights. And that has become increasingly important, I think, in human rights discourse. Less in the United States, but certainly in many other areas. That notion that dignity is the foundational principle of human rights goes significantly together with the comparative method. In other words, it isn't accidental that we have both a foundational principle of dignity being developed and a comparative method going on at the same time. And I suggest in the remainder of the paper that essentially they go together because the comparative method enables this notion of dignity or other foundational principle, whichever it is that you want, to be able to be talked about in ways that unpack a very fuzzy notion of dignity or whatever and make it operational. So what's the bottom line? The bottom line is that the comparative method, I think, is one of a series of functional methods by which extraordinarily vague principles or foundational principles of human rights are enabled to be discussed among agonists, among those who are otherwise essentially disagreeing about the substance of any human rights claim. So what seems to be emerging and suggesting is that the comparative method, along with the development of dignity, along with the development of notions of proportionality, is beginning to constitute an important methodological agreement on how to do human rights, whilst at the same time we're observing increasing disagreement as to what the substance of human rights, what the actual results of the application of the human rights method may require in any particular context. So I'm suggesting not, and it's important, and I'm not suggesting this, I'm not suggesting that there is an agreement-based consensual understanding of human rights at the substantive level. I'm suggesting that instead there is increasingly a methodological overlapping consensus as to how to do human rights, even though that does not necessarily result in any particular agreement on the substance of human rights themselves. Thank you.
Only bringing my phone up here so that there's not a clock so I know when to stop talking, but Brendan will throw things at me if I go too long. First of all, thanks, Brendan, for the lovely introduction, and Christopher for the very thoughtful paper. Clyde was a wonderful colleague, and has unfortunately passed on, but he was just a joy to get to know in his early years, my early years at the law school, so I'm glad that you got to know him even if he slept through your paper. I certainly didn't sleep through your paper and found it very engaging. Perhaps I have been jaded by two things. One, being a public international lawyer teaching in a law school, and two, spending 2.5 years at the State Department. And so perhaps I come at the question, I certainly come at the question very differently than I might have before my time in government, and some of what I say may be informed by that. And I guess the first place I want to start is by asking why it matters that we call something human rights in the first place. And it's something that I struggle with when I design a human rights syllabus, because in some ways, for me, that's a category of things that could include everything from the prevention of genocide to the right to vacation. And that it is a label that I find both over-inclusive and under-inclusive, and in so doing, sometimes ends up being hollow. I guess one of the things your paper did for me is to sort of get me to rethink some of that in terms of coming outside of the purely legal perspective, where saying it is a human right is somewhat meaningless. Saying it is a right in international law or a constitutional right in the domestic system of some state has meaning as a lawyer, but saying it's a human right doesn't do much work in that sense. But I think you have caused me to kind of to re-grapple with that question. And I wonder about the distinction between human rights and constitutional rights as well. And I know that that's something that you use as a jumping off point. Constitutional rights obviously has a meaning within a particular domestic system, and therefore is able to do work for you. But to say, it's a human right when you're operating in a domestic legal context, particularly in this country, may do you very, very little work. So, that's something I think that one presupposes the category has meaning, and I think it would be interesting to kind of dive deeper into why it has meaning. And if we come obviously to the moral rhetorical side, it certainly has meaning, but as a lawyer, it's something that I certainly struggle with. I also wanted to think a little bit, particularly about the comparative method, and your comments on it are extremely useful, and let me reflect on that from a couple of different perspectives. And the first perspective is, as a public international lawyer, the comparative method is in fact the source of human rights as an international lawyer. Obviously there are treaties and the Universal Declaration, but if you think about customary law, the way legal rules are created that bind states that don't consent is precisely through the comparative method. It's through finding a widespread and systematic, as you know, widespread and systematic state practice, which essentially means going and asking what other countries do, and if we find enough other countries doing it, and doing it because they believe they are bound by a law to do it, and in that sense, the comparative method has both purpose and great power. But the comparative method, so within the legal context, I think I fully embrace and understand why we do that. Partly, though, we do that because we don't have any other meaningful source from which to derive the binding legal rule. Because we could argue rhetorically, morally, and politically for a very long time and never find a way to agree with the human rights practices of a particular country or to convince them that we are right, and we turn the comparative method into essentially a way of finding tacit consent to a rule that the government has never consented to. That's very convenient if you're an international lawyer. It's probably unsatisfying as a moral philosopher as the source of the right. It's also there's nothing better than when a student writes an exam in a human rights law context, right? And they give you 3 examples of countries that have done whatever the practice is, and then derive it is a binding legal rule. And there's real hard work to that comparative method. The problem is it often gives us answers that we, as advocates of of human rights are uncomfortable with, right? If I had to come up with the international legal argument that torture is a violation of customary international law, I can do it, but I'm going to have to sit here and explain away the practices of whether it's a quarter or a tenth of the states in the world, and so that's when the comparative method starts to fail us, right? And so there has to be something else that distinguishes these rights as human rights or as morally valuable or morally important beyond just that comparative method. And I think it is precisely because we don't want to tackle that question as international lawyers that we defer so much to the comparative method. But you rightly step us outside of the purely legal framework and say, what about the process of human rights? And I'm not sure I fully understand what is meant by the process of human rights, and maybe that's something you can help us think through. To me, I suppose there is a legal process of argumentation in the law in which the comparative method does work. There is a political process of trying to secure those rights in states where they are not respected. And here again, the comparative method does a great deal of work. It's in fact the first place I'm likely to want to have recourse to if I'm going into some government and trying to convince them to recognize a right. It is probably more powerful than the moral argument or deriving the morality of the right. But here, I guess I do have to agree that it comes back to individual rights rather than human rights as a concept when you're operating in that sort of political context. I do agree that there is something greater in the collective rights that we call human rights than each individual one, but when you're engaging in the comparative process, when you're trying to make the political or the legal argument through comparative analogy, it is each individual right that you turn to. But again, as political argument, I think the comparative method is very powerful. Where it begins to trouble me is when I ask if it has moral authority, because it is essentially derived from what states do, and what states do is often deeply immoral. So I guess one question is, how do we square the comparative method as a source of rights discourse with our own internal conceptions of morality, or do we simply pick and choose? Pick and choose which states to look at, which practices to look at, and which ones to focus on. Well, what about here in the United States? Obviously, the U.S. Supreme Court has dabbled with the comparative method. It has been used in cases on the death penalty and death penalty for minors and other questions. And then there has been a great backlash against that, and there's some fun debates. You can watch Scalia and Breyer debating in their footnotes whether this should be used. But what is interesting is the grounds of the U.S. rejection of it, right? Because the grounds of the general U.S. rejection is one that, these foreign countries should in no way inform our constitutional discourse, right? Which brings us back to the distinction to some degree between a constitutional right, which somehow is supposed to be deeply grounded in a country's own identity and experience, and the comparative process. It's not that we don't think it is politically useful, but that there is this sense of American exceptionalism that drives that, which you don't see very many other places. I know Brendan has worked on the Iraqi Constitution, and I worked on the Rwandan Constitution back in the day, and the entire constitutional discussion around rights was a comparative process. And so I think once when you take it back to the constitutional space, obviously that comparative method is going to be there. But again, I think it's there in part because it's one of the very few tools you have available as a human rights advocate. And part of what frustrates me is trying to expand that toolkit. And unfortunately, when you are sitting in a government meeting room or an advocate working before some legal system, or even outside of that legal system to try to make the argument politically, that's maybe your most useful tool. And the question of sort of the original moral authority of the right is often either forgotten or hard or not very effective when placed into that context. Let me just look here at some of the other, these may not be coming in a particularly useful order, but, I also wanted to mention the sort of question of, back when we go to sort of defining what human rights are, which the question of sort of how broad a category it is. And I was deeply concerned. I had not focused on Rawls' argument before your paper, saying that human rights are those things for which there is a right to intervene. And my frustration with that is, of course, that narrows the category so much of what human rights are, or it vastly expands the circumstances in which international intervention are allowed. And I guess one question for you is sort of, how, do we just reject that approach completely? And there's obviously the question of what, how, then the step back to say, what about if it's just a matter of international concern? I don't know what's a matter of international concern. So, how, the nice thing about the Rawlsian argument is it creates a kind of tipping point, perhaps a tipping point that is simply what you find in the responsibility to protect, right? Where you have a kind of systematic violation of a very, very narrow category of rights. That leaves me frustrated. And I think that's part of why I get frustrated with the concept, the categorization of human rights at all. So I wonder, as I sort of step away from the paper a little bit, to say, first of all, maybe it isn't that helpful to ask whether it's a human right or a constitutional right, but rather it may be more useful to say, where are we trying to get this right realized, and what is the most useful way of getting there? And not debate whether it is necessarily human or constitutional or jus gentium, but simply ask, how do we secure its realization? Perhaps we believe that by deeming it a human right, we, as those who are engaging in the process of human rights, will be more effective. And if that's the case, then putting it in that category, and that's something international law does with jus cogens. We create this higher order set of norms precisely because we believe that by doing so, it will have either greater rhetorical or political or legal suasion. And maybe putting things in that human rights bucket does so. And I guess when it comes to the question of comparison, I think it's very useful, but it is a tool. And it is only one of the tools available. And I guess for me, part of the struggle is to say, which tools do we prioritize in this process? Yes, if you're asking, how do you define what is human dignity? Comparative method is one way of understanding dignity, but there's a lot of places where that concept is different. And the question I guess we have to ask is, to what degree do we want to embrace that relativism that may come from the comparative method, or to what degree do we want to hold a sort of categorical belief that we derive from somewhere else? And I think if I'm an international lawyer trying to advocate a right, I want to embrace the relativity in the comparative method, but make sure I've trained my students to be very good at figuring out how to use the comparative method effectively. But if I am a moral philosopher wanting to understand or define what those rights are, then I think the comparative method may in fact may frustrate that aim. Yes, it creates discourse, but it may create more disagreement today than it creates agreement. So I think I'm just under my 15 minutes, so I will stop there and turn the floor back over to you and Brandon.
Thank you very much indeed, Bill, and thanks, Chris. Chris, do you want to respond to any of the questions and issues raised by Bill?
I think I've got 2 or 3 points.
Yes.
First of all, thank you very much, and thank you for such a careful reading of the paper. I'm grateful. I particularly liked your saying that government service had maybe changed your opinion. I mean, part of what I'm particularly concerned to do is to reflect the broad notion of human rights practice as something more than judicial decision making, which I think it often becomes too close to, and to integrate exactly that kind of government practice into our understanding. So let me come to the 3 points. The first is your notion, your understanding of what I mean by the comparative approach. I didn't spend perhaps enough time in the presentation, distinguishing a political understanding in the Raz, Rawls, Weitz understanding, political conception of human rights, from agreement-based methods. And they go out of their way to distinguish these two, particularly Weitz in his most recent book. So there's a danger, clearly, in the comparative method being seen, partly because of the approach that's taken in customary international law, of seeing the comparative method as necessarily an agreement-based theory. Yeah? And many of the concerns that you raised with the use of the comparative method, I think, depends on an assumption that really it's going towards an agreement-based method. That is, that the notion, the way in which you determine what a human right is by having some notion of comparative method leading to an overlapping consensus in a Rawlsian sense, which then means that there is some moral obligation on you to uphold it. And what I'm suggesting is that what's attractive about political theories, Raz, Rawls, and so on, is that they don't adopt a kind of consensus method in that sense. They're adopting very much the perspective that you ended with, which is that human rights are a tool. And the question is, what function are they fulfilling? So that, I think we're on the same page on that one, and not simply going for an agreement-based method, because I think it gives rise to all sorts of problems. The question is, what is the tool that human rights are being used to further, right? And I think here is where we're in conversation. And I'm suggesting that if human rights is a useful term to use, and I'm bracketing that, if it is a useful term to use, then we should view its functions more broadly than those that Raz and Rawls identified, which is essentially international intervention, for the reasons that you stated. So then we get to the question about what its function is, what human rights function is, if it is more than simply international intervention. And if human rights practice incorporates a comparative method that isn't essentially driving towards a consensus-based understanding. Yeah? And that's where the problem lies. And it's in that context, therefore, that I'm suggesting that there is a methodological understanding of the use of the comparative method, driving towards the notion that you want to keep people that are otherwise dispute-ridden situations, at least in conversation with each other, and that comparison helps to perhaps keep people in conversation. So your reference to Rwanda, Iraq, Northern Ireland, and so on, where the comparative method seemed to be playing a role, you put it in quite a political role, in the sense of being useful. I'm suggesting it may be more than that it may actually play a role here of keeping people in conversation where otherwise they would not be in conversation. And that has a moral implication as well as simply a utilitarian distinction. You can see how that